Good morning. We welcome everyone to our October session of the Supreme Court, which would have typically been held in Pittsburgh, but is now being conducted once again by WebEx. Some of you have perhaps watched our previous sessions, and our experience has been it works fairly well. We're pleased to at least be able to conduct arguments via this technological means, and we think it's preferable, for example, to Supreme Court of the United States, which uses telephone conferences to argue the cases. Here we can see each other, and it gives at least the semblance of a traditional session. As always, I'll say a few words to state the case, and then we'll begin the arguments. And as always, we remind everyone that we do have the benefit of your briefs, so you need more at the end of the argument if you feel that a point wasn't reached, because we'll certainly take that into account. With those brief remarks, we'll call the first case.
Yes, Your Honor.
Sorry. The first matter is Tanya J. McCloskey versus the Pennsylvania Public Utility Commission and Metropolitan Edison Company. Representing MedEd is Mr. Anthony Decusatis. Representing the PUC is Mr. Scott J. Thomas. And representing Ms. McCloskey is Ms. Erin L. Gannon.
These consolidated appeals concern the regulation of public utilities and the amount that they may charge to customers. In particular, the court is asked to consider the effects of a statute approving rate increases to permit utilities to recapture infrastructure improvement costs, and another statute directing the treatment of income tax deductions and credits in rate calculations. With that, we can begin the argument.
Your Honor, before, if I may, with your indulgence, before beginning my opening remarks, at Mr. Minner's request, I'd like to take just a moment and explain the division of responsibilities between myself and counsel for the PUC to make sure we're not being repetitive. I will focus on the issue of plain language interpretation, section 13011, based on the premise that that section actually applies to a rate adjustment clause like the Distribution System Improvement Charge, or DSIC. Counsel for the PUC will focus on whether section 13011 was ever intended to apply to the calculation of the DSIC at all, or applies only to base rate proceedings, and whether the PUC's finding of ambiguity permits it to consider factors in section 1921C of the Statutory Construction Act, including deference to the Commission's interpretation of the Public Utility Code. And of course, both counsel will be prepared to answer any questions the court may have with respect to any of the issues presented. I hope that's helpful. Thank you. And I'll begin my remarks. In his opinion below, the Commonwealth Court reversed.
I'm sorry, Justice Breyer. Just before you begin, would you be nice enough to pronounce your last name for me? I don't think we've ever met.
Thank you, Your Honor. Yes, it's Decusatis.
Thank you.
In the opinion below, the Commonwealth Court reversed a PUC rate order claiming that it was applying the plain language of section 1301.1. In fact, the court departed from the plain language of the code. In this case, we are asking the court to find that plain language interpretation includes, as it should, reading a provision in context as part of its statutory structure and overall legislative design, and applying those canons of statutory construction that are not predicated on ambiguity. This court should confirm the DSIC's legislative purpose of accelerating the rehabilitation of vital utility infrastructure and accordingly reverse the Commonwealth Court's opinion, which misapplied principles of plain language interpretation in 4 ways. First, Section 1301(1) is a general provision. The Commonwealth Court's interpretation of that section conflicts with specific operating instructions for calculating and applying the DSIC that are prescribed in other sections of the code. And for that reason, the court below did not follow the directives of Section 1933 of the Statutory Construction Act. Second, the Commonwealth Court did not apply the entire statutory definition of rate in Section 102 of the code, which includes rules, regulations, practices, and classifications that may affect charges. Proper consideration of that definition, Section 1301(1) can be and should have been interpreted to align with the formula for calculating the DISC in the DISC-specific sections of the code. Third, contrary to precedent of this court, the Commonwealth Court inferred an unexpressed legislative intent to rewrite precisely defined statutory operating instructions for the DSIC. Its interpretation, therefore, attempts to insert language into the DISC-specific code sections that the legislature did not put there. Fourth, the Commonwealth Court did not consider the inconsistency its interpretation creates between subsections A and B of Section 1301.1 itself. In a subsequent opinion, the Commonwealth Court adopted an interpretation of subsection B that underscored the legal inconsistency that we had previously identified between those subsections, but the court, in our case, declined to consider. In conclusion, the conflicts and inconsistencies created by the Commonwealth Court's interpretation could have been avoided if the court had applied the plain language of Section 102's entire definition of rate. It did not do so, and its decision should therefore be reversed.
Thank you. Questions?
Counsel, Mr. Thank you. I apologize. I might just say counsel.
No problem.
One of the challenges on our court is our jurisdiction is so vast. And I confess that this is somewhat Greek to me. And I don't understand how Section 301.1 is clear at all. So why don't you pretend that I'm in 3rd grade or 4th grade and explain to me the really in plain language, and I'm sincere here, what sentence 3 says and how sentence 3 is inconsistent with sentence 1 and 2.
Yes, Your Honor, if you indulge me for just one moment. I just, if I may, I just want to be clear that we were pointing out the inconsistency between subsection A and subsection B of Section 1301.1.
All right, let me make sure that I'm talking to the right party. The Commonwealth Court found no ambiguity. Is that right?
The Commonwealth Court did not.
Okay, and you say there is ambiguity.
Your Honor, if I may, I think I think it's important to clarify that what we have addressed is really 2 modes of analysis with respect to Section 1301.1, and they begin from two different. Premise 1 is, let's assume that Section 1301.1 was intended to apply to adjustment clauses like the DSIC and is not restricted to this category of cases referred to as base rate cases, which is a fairly significant distinction. Beginning from that premise, the question which we addressed in section
Okay, it appears that for the time being, we've lost
to determine what it says,
We're back.
and to determine whether it is consistent with how the commission has always applied the DISC.
May I interrupt you for a second? You
Yes.
don't know this, but you're not certainly no fault of anybody's. Your video stream stopped on us for about 10 or 12 seconds. So you need to back up if you possibly can, 10 or 12 seconds, because I'm intensely listening. I would like the answer.
Certainly, Your Honor. Yes, as I was saying, beginning with the premise that 13011A applies to the DSIC, if you do a textual analysis of the plain language to find out, ask the question, is it consistent with the way the commission has always calculated the DSIC? And in our submission, it does. And it turns on the question of rate, and it turns on the question of whether the term rate includes, as we believe it does, and as we have demonstrated that it does, all of the terms and conditions that are in the distribution system improvement charge mechanism, all of the operating instructions for calculating the DSIC. There is a second mode of analysis which starts from a different premise and asks a different question, and that is, was 1301.1 ever intended to apply to adjustment clauses like the DSIC, or was its import, its legal import, cabined within base rate proceedings and restricted to the purpose of eliminating these so-called consolidated tax adjustments, which had only ever been made in base rate proceedings? And it is as to that issue, as we addressed in section 8C of our opening brief, it's that second issue, the overarching question, what does 1301.1 even apply to the DISC, where there is textual evidence of ambiguity, there is structural evidence of ambiguity, and that ambiguity is certainly sufficient, in our view, to allow the court to look at the 8 factors of section 1921C, such as the purpose behind 1301.1, the legislative history, and prior commission interpretations, and potentially deference to the commission's interpretation of the code. So I think it's important to make that analytic distinction. And what I was planning to address first was, let's begin with the premise that 1301.1 actually applies to the DSIC. And let's do a plain language interpretation, textual analysis, and ask the question, as written, can the commission's calculation, the way it's always applied the DISC in the past, conform to and meet the requirements of 1301.1? And we believe it does.
Counsel, it's Justice Donahue. Can I just follow up on Justice Beer's question? Are you saying it is not your job today to answer the question that he just asked? He's asking where the ambiguity is in the section 13011. Is that another counsel is going to address that issue? From a different predicate?
I would be happy, Your Honor. I would be happy to address that. That is the question that goes to, does 1301.1 apply outside of base rate proceedings to a distribution system improvement charge. That's sort of a threshold question. And the ambiguity derives really from several factors. There is a textual analysis that we've addressed in our brief in section 8C. There are words and phrases that are used in section 1301.1A that are not consistent with
Okay, we're having a problem with the audio again, so we're going to move to Mr. Thomas from the PUC because you both stand in the shoes here.
involves the terms rate base and final order, which we've discussed in our brief.
Counsel.
There is also a structural ambiguity.
I'm sorry, sir. We're having trouble with your end of the audio, so we're going to hear from.
I apologize. We're losing some audio.
Yeah, well, that's not your fault, but we're going to keep moving forward here, and maybe at the end we'll let you answer a question or two. But Mr. Thomas, can you pick up this argument?
Can you hear me?
I can hear you. We can hear you. Can everyone hear Mr. Thomas?
Yes.
Yes.
Now, this is the same case, so I think you can answer the court's questions, hopefully.
Yes. The question.
Mr. Thomas, it's Justice Baer. And again, Justice Donahue and I think, are seeking the same thing. So let me cross-examine gently to try to see if we can get an answer, okay?
Okay.
Okay. In sentence 1 and sentence 2 of 1301.1A, it discusses public utilities rates. Is the disk inside the rates? Is there a dispute concerning that?
One word near the end cut out is a dispute in the rate. I couldn't get that.
I said, is there any dispute that a disk charge to a consumer, to a consumer, is part of a rate?
Your Honor,
We have base rate.
The disk is a rate.
Okay, disk is a rate. So
Yeah.
in looking at sentence 1 and 2 of 1301.1, they seem pretty clear to me that the that the income tax deductions and credits, whether they be for adding or subtracting, are part of the rate calculation, therefore part of the disk rate calculation. Now, is that right?
No, Your Honor, and that's where we believe the issue of ambiguity comes from, and it comes from two places. We believe that the Commonwealth Court failed to take into effect the full definition of the term rate at Section 102 of the Public Utility Code, and the Commonwealth Court, on top of that, failed to look at the language of the statute in its proper context. And the interplay between those two topics is where the ambiguity comes in.
So why don't you elaborate that, and maybe we can get to the point where we have some, I can speak only for myself, so that I have some confidence that I understand what I'm deciding.
And counsel, it's Justice Donahue. When you're answering that, could you look at the third sentence that uses the term rate base? Is there an ambiguity created between the first sentence and the third sentence, or not?
That is our position, that the third sentence of Section 1301.1A refers back to the first two sentences and identifies to which rates, base rates, the computation of the income tax adjustments in the first two sentences calls for. And that along with the full statutory definition of rate is where we believe the ambiguity.
So let me interrupt you again, only because your time is waning, and I don't think we're getting very far. And Justice Donahue and I think are on the identical Quest, thank you. And again, so I don't want to cut you off, but I want to try to get an answer in the time you have. We've already been told that rates include, in the first two sentences of 31011, include disk rates. So go ahead then and explain how, I don't understand what sentence 3 means in all candor, but whether the term rate base there somehow creates an ambiguity in the term rates in sentence 1 and 2. I think, isn't that, Justice Donahue, where we are?
That's correct.
That's what we need to know.
Yeah.
Otherwise, we're going to have to decide this case without the benefit of oral argument.
All right, and the rate base in the third sentence is a technical term. It's defined in section 102 that relates specifically to the calculation of a utility's base rates. And when you factor that in and the full definition of the term rate at section 102, the third sentence, referring back to the first two sentences, identifies which rates that the computation of income tax deductions and credits applies to, and that is to base rates, not to disk rates or other alternative rate-making mechanism rates.
I think we're getting somewhere. Just elaborate for me why you say that. I understand what, and it's taken me hour upon hour upon hour. I'm sure all my colleagues also. I understand what the rate base is, what the base rate is, what the rate is, and what the disk rate is. I don't see the ambiguity. It seems to me that I don't understand what the third sentence does. So I understand the first two sentences, they apply to rates, which includes disk rates. What does the third sentence do, and why? How do you see an ambiguity when obviously the legislature understood what a rate was, including a disk rate, and understands what a rate base is, which is the basis to come to the base rate, distinct from the rate. Does that make sense to you?
I believe so, Your Honor.
Okay.
And again, that's where there are two pieces to this. The full definition of rate at section 102 includes the practices and rules and regulations that affect the charge. And when you look at those practices and rules and regulations that are contained in sections 1350 to 1360 of the Public Utility Code, and then you look at the three sentences of section 1301.1a. Again, you can't just look at the dictionary definition of words. If you view the term or the statute in its full context and consider the full definition of rate, it's ambiguous regarding whether it applies to the calculation of a disk rate. And that's because, again, as you said, the term rate is used in the first two sentences and rate base in the third. Rate base is a term that's used in the calculation of a utility's base rates, not its alternate rate-making rates or disk rates. And that third sentence, it refers back to the first two sentences. It identifies which rates, being base rates, that the computation of the income tax deductions and credits in the first two sentences applies to. So the third sentence is saying that this calculation called for in the first two sentences applies to base rates. That's what that third sentence does, and that's where the ambiguity arises, and that's why the commission properly looked at Section 1921C factors.
Mr. Thomas, let me interrupt you one last time, and it'll be, I hope on this subject, my last question, and I apologize for the nature of the colloquy, but I don't get that at all. And again, I want to give you every opportunity. In the first two sentences, the legislature used the word rate. It's defined by 102. We know what it means. In the third sentence, it used the term rate base. And again, we know what that means, and that has to do with the base rate and not with the rate. So I don't see the ambiguity. And again, I'm not going to badger you, but I want to give you a full opportunity to explain it to me.
That is the idea in those first two sentences.
I can't pronounce it.
Referring to rates. The third sentence tells you by mentioning rate base that the calculation called for in the first two sentences applies to base rates and not any other rates. That's
Can I jump in there? I see what you did there. you're conflating rate base and base rate. That was a little leapfrog. I'm not sure I understand how you do that, because doesn't rate base have its own definition in section 102?
It does, Your Honor.
So conflating those two, I'm just not sure I understand that's such an easy step. Can you flesh that out? I mean, what's the basis for that in the statute? That doesn't have any meaning that the legislature differentiated those terms?
Yes, and what we see is that the rate base is the value, the definition, which you know from section 102, as being something that is a part of a base rate case, but not a disc rate case, and that's where, again, where the ambiguity lies. Does this apply to all rates or just base rates?
But if it meant, if the General Assembly meant base rate instead of rate, why wouldn't they have just said that? I mean, doesn't base rate appear throughout the code?
It does appear in other sections of the code. Here, based on that full definition of rate in section 102, we believe it was it was, I don't know, inartful drafting, inartful wording, but that's where the idea comes from, that there is ambiguity.
Thank you, Mr. Thomas. We certainly understand the approach you're taking to the case, and you know, we could allow you another sentence or two. We don't know if we can get Mr. Deku's status back or not, but we're at the half an hour mark, and we have to hear from the Aplt. But there is this notion too that intertwines. These are obviously complicated issues in statutes that are somewhat difficult to parse through, and there's this notion of agency deference, where the agency charged in the first instance with interpreting the statute has to make sense. So I haven't heard anybody mention that we should give any deference to the PUC.
Good.
But maybe you don't think we should.
No, Your Honor, we do believe that's the case, and we also
half an hour into the argument, I never heard anybody say that, but you know, that's usually a factor when you're interpreting the statute that you're charged with the legislature with implementing.
Yes, and that would have been part of my opening statement. Had things gone as they expected, but there's also the issue that the Commonwealth Court committed 3 errors outside of the issue of ambiguity that are 3 reversible errors.
Maybe we can talk about that if we have another 15 minutes, but do you want to run through those 3?
Well, the first thing is, one, they failed to follow the rules of statutory construction, which Mr. DeCasado touched on, requiring the courts to construe general and specific statutes in a way that gives effect to both. Under Section 1933 of the Statutory Construction Act, between statutes, you should construe them if possible to give effect to both. We had a general provision in Section 1301.1 and a special utility rate making provision in Section 1337 that contained all the elements of the calculation of the DISC. And what the Commonwealth Court holding effectively did was ignore Section 1933 and it's implied that simply because Section 1301.18 was enacted, Section 1307 or 1350 repealed or superseded Section 1357, and that's not the case. Also, the Commonwealth.
Counsel, wait, Justice, follow up on that. Could you give us a pragmatic, realistic example of what the monetary impact is of the Commonwealth Court's interpretation? Because as I understand the arguments in the briefs, as a result of this, the ability to recoup the costs of rehabilitation and improvement of infrastructure is significantly impacted by the Commonwealth Court opinion. I'd like to understand exactly, or within some parameters, what the impact is.
We don't have an exact number on that topic or on that question. But what the consequences are is, again, the holding of the Commonwealth Court, if that's upheld, could have a chilling effect on utilities, especially smaller utilities, in terms of whether or not they actually go ahead and take advantage of this great mechanism. And if they fail to do so, that has a harmful effect on the public in general, in that it will slow or stop the accelerated replacement or repair of aging distribution system infrastructure.
But we don't know, you don't know that that's going to happen. That's what I'm trying to get my arms around, because there's sort of a doomsday scenario that's articulated within the briefs on the impact that this is going to have on this obviously beneficial and needed effort. But you're saying what? It may or it may not have that impact?
We believe it's a potential consequence of affirming the Commonwealth Court's holding. We don't know that. We don't have a dollar amount on that. I believe Mr. De Cusatis has some information on that, or may have been prepared to address that in his portion of the brief before he got cut off. But that's the situation. We don't have a dollar amount. We believe it's a potential consequence that has to be considered.
Thank you.
Thank you. Okay, well, I think now we can, unless somebody has a final question or so, we can hear from the consumer advocate. Gannon.
Thank you. I apologize getting myself off of mute here.
Not easy.
May it please the court, Erin Gannon for the Pennsylvania Office of Consumer Advocate. While rate making is not simple, this is a straightforward issue of statutory construction. Section 1301.1 specifies when income tax deductions must be included in the calculation of income tax expense for setting utility rates. It requires that, and this is the first sentence, that if the investment is included in the calculation of rates, so are the related tax deductions. The second sentence addresses if the investment is not included in rates, then neither are the related tax deductions. The appellants argue that the DSIC should be an exception to Section 1301.1, but they are asking the court to read a limitation into the statute that doesn't exist. Section 1301.1 contains no language that limits its application to a specific type of rates. With regard to the questions that have been raised today, tried to make notes of those, and I'd like to get through those. The first question, I believe, was raised by Justices Baer and Donahue with regard to what these sentences of 1301.1 mean. And as I've explained, the first sentence is addressing when investment is included in rates, which is the situation with the DSIC. The DSIC is recovering the utilities plant investment that's not already reflected in its base rates. So it's between rate cases, the additional investment, the incremental investment that's made, that's not already being recovered in rates. The third sentence of the statute is specifically addressing the elimination of the consolidated tax adjustment, which falls into the second sentence of 1301.1a. That is where the utility the rate is not recovering investment that is made by that utility. What the consolidated tax adjustment did was recognize that when a utility is filing a consolidated tax return with affiliates or in a parent company, that the tax savings that it receives from doing that consolidated tax return may not be generated by investment that the utility itself made. It's benefiting from investment that perhaps a parent or an affiliate made, and it's sharing in those tax savings. So the third sentence is really just to specify that the consolidated tax adjustment isn't addressed and included within that second sentence of 1301.1A.
It doesn't, I'm sorry, Ms. Gannon, this is Justice Baer again. You triggered something in my mind. Does the third sentence either put into law or a prior Commonwealth Court decision or reverse a Commonwealth Court decision? And I'm Paul, I can't give you the names because they're all McCloskey.
Yes, it does not, the third sentence does not reverse one of the recent McCloskey cases. What it does is it reverses decades of Pennsylvania appellate precedents regarding the consolidated tax adjustment. The decades of case law said that customers should not be paying what we call phantom taxes. The utility should not be able to calculate rates as if it is not receiving tax savings. It should only be able to pass through the actual taxes that it will pay in the rates it charges to customers. And that second sentence of 1301.1A eliminates that consolidated tax adjustment that had traditionally been made.
And in your view, and that's helpful, and I appreciate it, in your view, when the third sentence used rate base, which translates to the base rate rather than the full rate, which includes the disc, does that make sense?
I do understand your question. However, the usage of the term rate base, again, that third sentence is really specifically expressly stating that the consolidated tax adjustment is reversed. And the consolidated tax adjustment is addressed in base rate cases and involves rate base. And that is why the term is used there, I believe. But another important clarification, the term rate base is not exclusive to base rates. DSIC rates and base rates both recover the value of utility property that is used and useful in the public service, which is the statutory definition of rate base. The DSIC recovers the depreciation and pre-tax return on investment that's not already being recovered in base rates. And then in the utility's next base rate case, that same plant investment that's recovered in the DSIC will be rolled into the rate base on which the utility earns depreciation and return through its base rates.
Ms. Gannon,
Yes, Justice
Fund, are you telling us that if we can arrive at a comprehensive understanding of this statute and of your position, that 1301.1A is not ambiguous?
Correct. It is not ambiguous. Its plain language applies to rates, and there is no basis to read a limitation into that plain language that does not exist. It is entirely possible to reconcile what the change that 1301.1 is requiring with the existing DSIC statutory provisions. Those are addressed in detail in our brief. One point of explanation for purposes of today's discussion. The DSIC provisions really address tax rates, whereas 1301.1 is addressing the income tax expense calculation. And when you consider it in that way, it is entirely possible to see that 1301.1 really supplements rather than conflicts with what is contained in the statutory provisions relating to the DSIC specifically.
Thank you.
Can I follow up on that question, please? Should we be concerned when viewing this case, the fact that Section 1357, which details the method for computing the DSIC, does not give any reference to the language and the intent as you're reading it of 1301.1?
No, Your Honor, I don't believe that it does create any concern. The DSIC provisions are silent with regard to the calculation of income tax expense. They address only the income tax rate that should be used in the calculation. I view the DSIC, the calculation is really setting the boundaries on what can and cannot be recovered through the charge. And so it's setting those upward boundaries. It addresses the type of property that can be included. It addresses the fact that you can recover the return of and on, you can recover the depreciation on the investment, and you can recover the pre-tax return, which includes income tax and profits. And that really is something that makes the DSIC different than other surcharges. And it also limits the impact of application of 1301.1. At this point, the only surcharges approved by the Commission that recover income tax expense and investment, which are addressed by 1301.1, are base rates and the DSIC. So the DSIC is definitely a unique statute in that it is not a simple statute that just recovers dollar for dollar expenses. It also recovers the profit and the depreciation and the income tax expense.
Would you agree that the your opposition here, though, may have the argument that if 1301.1 was to be interpreted as you do, that certainly the legislature could have taken the time to reach over into and added the impact of that section to the definition of the DSIC?
Yeah. I take your point, and that is one of the arguments that has been raised. However, I don't think that it is necessary, because it is not necessary to read a conflict into the two statutes. The 1301.1 really operates to supplement what it's expressly stated in 1357, and 1357, the calculation provisions, does not mention income tax expense at all. It is silent with regard to income tax expense. It only specifies the income tax rates that are to be applied. And there has been there's discussion in the briefs regarding the mechanism, the way to implement 1301.1 and how that is done. But the bottom line is that utilities, they are paying taxes at the statutory income tax rates. The distinction between the tax rates and the tax expense is that the tax deductions are reducing their taxable income. And that is what 1301.1 is focused on, is accurately reflecting what the tax expense is for the utility. And that is not something that is spelled out within the existing DSIC provisions. So for that reason, we do not think that it was necessary to amend the DSIC provisions. Conversely, we do think that if the General Assembly had intended to limit 1301.1 to base rates, that it could have specifically included the term base rates rather than rates. And we think that is very significant because, as one of the justices mentioned earlier, I believe it was Justice Weck, the term base rate is used throughout the Public Utility Code, and it has been used in statutes that have been enacted since Act 40, to be very clear about when the statute applies just to base rates and when it applies to other forms of rates.
Council, it's Justice Donahue. If you can maybe help me with a question that I asked one of your opposing counsel. Is there a significant impact on the revenue that's generated through application of the DISC and the DISC calculation as a result of the Commonwealth Court's interpretation in the one that you are offering? Because it's obvious that the DISC was intended to provide revenue in a different stream in order to rehabilitate and create new improvements to the infrastructure. So, what is the impact on that decision to create that stream of revenue on application of the interpretation that you're urging?
And I might just add to Justice Donahue's comment, you are the consumer advocate, and they're arguing that this is going to be prejudicial to consumers.
I will address that. Thank you. With regard to the monetary impacts, The Attorney Thomas was correct that within these cases, the monetary impact was not quantified. Our discussion was focused on whether or not the utilities were required to make the adjustment, so they were reluctant to actually calculate the adjustment. However, in some prior cases regarding the OCA's recommendation to make this adjustment before Act 40, there was some discussion about the amount, and we were looking at one specific utility that was in the Columbia decisions, and the estimate was at that time for that company in that quarter, it was approximately 0.1% of the DSIC. So the DSICs have a charge cap of typically 5%. So we're talking about a 1/10 of the percentage, again, for that utility in that specific quarter. But in order of magnitude, the elimination of the consolidated tax adjustment, we did estimate that was going to have tens of millions of dollars, multiple millions of dollars, tens of millions of dollars impacts for just 7 utilities that we looked at on an annual basis, because the consolidated tax adjustment is addressing the utility's entire tax expense, the overall annual tax expense, whereas this is dealing with the incremental income generated by the investment that is recovered through the DSIC, which, as we've said, is limited to 5% of customer bills. So in orders of magnitude, the impact of eliminating the consolidated tax adjustment, what the second sentence of 1301.1 does, is far, far more significant than what the impact of this adjustment from the first sentence of 1301.1, from the impact that would have. So relatively, in terms of the impact on consumers, their rates are going to go up because of the elimination of the consolidated tax adjustment. They're going to go down slightly because of the requirement that you change the calculation of income tax expense in the DSIC calculation. So as a net, the impact of 1301.1 is to increase rates, all else being equal. But with regard to what we're arguing here today about the impact on the DSIC, that would serve to reduce rates, again, all else being equal, if the utility has tax savings related to the income, the investment made and recovered through the DSIC.
And if you decrease the rates, Council, if you could just follow through with me on that, that means that there's less revenue available for the infrastructure improvements, et cetera.
I do not agree with that, respectfully, Your Honor. As it is now, what is recovered through the DSIC is the utility's investment, as well as the depreciation on that investment, the profit on the investment, and also the income tax expense. As it is now, the tax deductions are not being reflected in the income tax expense. So the utilities are essentially over-recovering. They're being made whole, and they're being paid additionally on top of that for income tax that they're not actually paying if they have income tax deductions that are not being reflected in the rates. And that incremental overpayment is going to continue as long as the DSIC is charged. Once we get to a base rate case, then it will be addressed because the tax deductions are reflected in the calculation of income tax expense for purposes of setting base rates. But in each quarter, the customers are essentially overpaying on the income tax expense because of the way that it's being calculated currently. So if 1301.1 applies to DSIC rates, that will actually continue to make utilities whole. They will recover their actual income tax expense because those tax savings are reflected. They'll still make the same profit that is allowed through the DSIC calculation. They'll still recover their return on their investment. So utilities will continue to be made whole. The interesting impact also of reflecting the tax deductions in the calculation is that as it is now with the 5% or 7.5% charge cap on the charge that the DSIC charge itself, if a utility is getting close to reaching that cap, so it's making investment and it's nearing that cap, even if it makes additional investment, it's still limited as to what it can recover through the DSIC. So if the DSIC rate is reduced to reflect tax deductions, it would actually, all else being equal, reduce the DSIC charge. The utility could make additional investment within the cap itself. So 1301.1 doesn't affect that cap. They can still charge 5% or 7.5%, wherever they can justify, but this would have the somewhat counterintuitive impact of providing additional recovery through the DSIC. One last point on that question is that the DSIC, it's not a funding source. The DSIC is only to recover investment that is already made. So to say that it's reducing the revenue available for investment is not really how the DSIC works. It is reducing effectively the extra revenue that ratepayers were providing because the tax deductions were not reflected in the calculation.
Okay, thank you. Thank you,
Thank
Council.
you. That's very ably stated. So we appreciate the arguments of both parties, and we'll take a 5-minute recess and then call.
This case is Commonwealth of Pennsylvania versus Joshua Wardlaw. Representing Mr. Wardlaw is Mr. Brandon Ging. Representing the Commonwealth is Mr. Michael W. Striley.
Good morning. Generally, under the rules of appellate procedure, a litigant must await a final judgment before filing an appeal as of right. In criminal cases, however, a defendant may appeal the award of a new trial where he claims that the proper disposition of the matter would be an absolute discharge. Appellant was a defendant in a criminal trial that resulted in a mistrial after the jury deadlocked. He filed motions seeking arrest of judgment and acquittal, which the trial court denied. Appellant then lodged an appeal, taking the position that a new trial had been awarded, thus triggering the noted exception to the final judgment rule. The circumstances are also unusual in that both the Commonwealth and the defendant appear to agree that an appeal was proper, and we'll take that up in due course, but we'll call on Mr. Ging to introduce himself and say a few words.
My name is Brandon Ging. I'm from the Allegheny County Public Defender's Office, and I represent the appellant, Joshua Wardlaw. I'm very honored to be arguing this morning. As you indicated, Chief Justice Saylor, this is a procedural question, and it's whether the Superior Court, in quashing my client's appeal, misconstrued the rules of appellate procedure and interpretive case law. We maintain that the Superior Court erred, and as you alluded to, so does Mr. Striley and the Commonwealth. I do think that's an important point to note. Mr. Striley and I have been opposing counsel in cases for going on 13 years.
What position did he take in the Superior Court?
Mr. Striley took no position with regard to quashing in the Superior Court. And I would maintain it's because, well, as he does now, he believed that the appeal was proper under Rule 3.
Well, let's take that up because, and not to interrupt your summary of argument, but there's a rule of criminal procedure that I'm interested in. It's 587B. You familiar with that?
Your Honor, I'm not sitting here right now. It's not something that I've looked up in anticipation of the argument.
It talks about motion for dismissal and double jeopardy. And while the Allegheny County DA's office may agree that this appeal was properly lodged, there's 67 counties in Pennsylvania. And when we look at these cases, we have to make sure that there's no deviation across all these counties in terms of being able to seek appellate review. So I don't know if you have a copy of the rules with you.
I can certainly look it up, Your Honor. Now,
what I'm getting at is there's supposed to be a determination. There's steps you go through in this situation, one of which is you need to secure a determination of non-frivolous from the Common Pleas Court. Was that secured here?
Well, this case, I would say yes and no, Your Honor, because this case actually presented another appeal. In as much as we are challenging in this particular matter whether the evidence was sufficient to even go to the jury, we actually raised another appeal that the sua sponte declaration of a mistrial was not based on manifest necessity. In that particular matter, we did file the motion. Prior counsel did file a motion. The trial court ultimately found that matter was frivolous. And because of that, we did have to petition the Superior Court for review as opposed to appealing it as of right. So I think that matter is separate and distinct from what we're dealing with today. Because
an appeal is an appeal is an appeal. You only get one appeal from a criminal conviction. You don't get two appeals on different bases. So the question is, looking at the whole record, was that appeal properly taken?
I believe so, Your Honor.
You really need to be, it's a double jeopardy situation, isn't it?
It is. In both contexts, it is a double jeopardy situation.
Then you have to look at the rule of criminal procedure that guides you. A motion to dismiss on double jeopardy grounds, etc. But anyhow, I don't want to monopolize the argument.
Well, to address your point, if I may, Your Honor, I do think that as I interpret the rules, it does require two different mechanisms to appeal. And that's because in this situation, based on our interpretation of the rules of appellate procedure and the case law, particularly the Chenet case and the Liddick case, which are Supreme Court cases, as you alluded to, where the claim is based on a lack of sufficient evidence, I believe that's appealable as of right. But with regard to the 587 aspect, the argument there wasn't based on because of insufficient evidence. It was based on the notion that the trial court's sua sponte declaration of a mistrial.
Well, let me stop you again, and I don't usually do this, but listen to this question. Isn't the sufficiency of the evidence issue intertwined with a double jeopardy concern? Namely, that the individual should not be twice put in jeopardy when the government has failed initially to adduce sufficient evidence to support a conviction.
Yes, I would agree with that, Your Honor.
Well, then you go to the rule.
I guess in that way, I would say that 587 in the rule of appellate procedure we're dealing with now, 311A6, are distinct. That would be my position as to why we proceeded under two different mechanisms here.
Yeah, but can I just jump in and follow up on the chief's question? It seems you've arguably picked the wrong horse, or you've at least not followed the rule. We're dealing with the rule that we have on the books here, and I don't see your client was not awarded a new trial. It's a mistrial, and we have a procedure for that, as the chief was discussing. I know it's familiar to you in your practice. So I don't know whether you're trying to get us to revive this exceptional circumstances doctrine, because you're not giving us a textual analysis of 311. And to the extent you are, why is Mr. Wardlaw so exceptional? Because as the chief pointed out, we do have 67 counties. Upon reflection, maybe we should have asked the DA's Association to give us an amicus brief, but we had no idea that the Commonwealth would take a knee here. I just don't know if we take your argument here and accept it. We've crafted a Wardlaw exception of unknowable proportions in derogation of the pathway that exists under the rules, manifest necessity, non-frivolous, etc. Can you explain why this case is so exceptional?
In this particular case, from a factual standpoint, the Commonwealth's only evidence against my client was the testimony of the two surviving victims. They both testified at trial that they could not identify the shooter. So the Commonwealth introduced prior consistent statements where they identified the shooter. The jury came back and acquitted my client of, I believe, the 2 counts of attempted homicide and hung on every other charge. Our position was that the Commonwealth has the burden of proof. And because their own evidence presented 2 different competing viewpoints, this wasn't as though we were basing our argument on any evidence presented by the defense. That the case would have never gone to the jury to begin with. Okay,
but just your juries hang all the time. Mistrials are declared all the time. I know you deal with this.
Yes.
As the chief pointed out, we have the 586, and you do the double jeopardy dance. And if you get there, you get there, and if you don't, you do your trial. But aren't you putting a square peg in a round hole here by trying to characterize this as an award of a new trial? You don't have a post-verdict motion for a new trial and an award of a new trial. You have a jury hanging, the jury hangs, and there's a mistrial. So why aren't we talking about 2 different species of cases? Statewide.
I'm sorry, Your Honor?
Statewide. 2 different species of cases, statewide implications.
My response, Your Honor, is as I interpret the rules, the 587, I don't believe in 311A6, I think that they speak to 2 very different types of issues. in as much as both implicate double jeopardy. One is based on a grant of with regard to manifest necessity, whether a mistrial should have been declared. But in this particular case, the issue is based on whether or not the evidence was sufficient to even go to the jury. As I interpreted Rule 587 and Rule 311A6, I believe that they're separate and unique, and they don't blend, they don't encompass one another. I certainly don't want to do any more work than I have to, but as I was interpreting the rules, that's why I proceeded under two different appeals, because I interpret Rule 311A6 as requiring an appeal as of right with regard to this limited issue. That to the extent we claim that the declaration of a mistrial should have not have happened, we couldn't have sought to appeal that under A6. The way I was reading,
I apologize. Can I finish your answer to Justice Weck?
as I was interpreting the case law with regard to A6, and it's not very, there isn't much. I'll be clear. I don't think that there's much out there. But I came across the Chenet cases and the Liddick cases, and it specifically said where the claim is based on a lack of sufficient evidence, then you can appeal it as of right, that double jeopardy should attach. But if the claim isn't based on a lack of sufficient evidence, you have to proceed under the rule that Chief Justice Saylor alluded to, and that's 587. Then you'd have to go to the trial court and see whether or not they make a finding of frivolousness. If the court finds that it's not frivolous, you can then proceed through an appeal. But if they do find it's frivolous, then you have to petition the Superior Court for review. That's my interpretation of the rules.
Counsel, I have a question. Assuming that the constitutional right that you're implicating in your sufficiency challenge is double jeopardy, how do you get around the United States Supreme Court's case of Richardson versus U.S., in which it clearly indicates that a deadlocked jury does not implicate double jeopardy? And that's a 1984 case, so that predates.
I appreciate that, but our position is that the Commonwealth never presented sufficient evidence to allow this case go to the jury in the first place. They shouldn't get a second opportunity to try to present that sufficient evidence. And I understand that the jury came back hung. Typically, I would venture to say that once the Commonwealth closes its case, most defense attorneys make a motion for judgment of acquittal, and oftentimes those are denied. And then you ultimately go to verdict.
And counsel, with all due respect, counsel, here's a direct quote from that case. Regardless of the sufficiency of evidence at petitioner's first trial, comma, he has no valid double jeopardy claim to prevent his retrial. That's complete contradiction as to your argument. How do you get around that, what the United States Supreme Court issued?
Well, Your Honor, that would seem to be a complete contradiction to what we're saying. But again, I would hearken back to if the case should have never gone to the jury in the first place because their evidence was insufficient to allow it to go to the jury. They shouldn't have a second opportunity at it.
Okay, let's follow that. So what you're really saying is the Commonwealth should have null-prossed the case prior to proceeding, but they did not. Now that they proceeded and the United States Supreme Court said jeopardy doesn't attach, jeopardy didn't attach, therefore they can retry. So other than you asking the Commonwealth to withdraw prosecution, what sustains your argument?
I'm sorry, Your Honor, could you repeat that one more time, please?
Sure. What you're saying is that there's no sufficiency, so you should be able to challenge it. What you're really saying, despite the United States Constitution, United States Supreme Court saying otherwise, is that you really believe the Commonwealth should have null-prossed this proceeding for a lack of sufficiency. But we're not there. Right now, we're at a case in which they did, resulted in a mistrial. Jeopardy does not attach, and as you know, the Commonwealth is permitted to retry. Explain to me, other than you're asking us to create, an exception?
I wouldn't regard it as an exception, Your Honor. Ultimately, again, my position, and I apologize if I'm just, sounding like a broken record here, but our position is that when a motion for judgment of acquittal was made at the close of the Commonwealth's case, that they didn't present sufficient evidence to allow this case to even go to the jury, that the trial court erred.
But that happens all the time. I mean, Justice Cochrana's question is apt because you're not giving us any limiting principle. This is not just Mr. Wardlaw's case. It is for you. But for us, it implicates statewide issues. And I guess your argument, and this, you did not go the double jeopardy route. You did not make that argument, which I think is telling. Instead, your argument is, I guess, Mr. Wardlaw's really, really special because the case just wasn't sufficient. There are hundreds of cases around Pennsylvania, some of which are in trial today, where defense counsel would make that argument. And I suppose if your argument is credited here, we may need to consider how the Superior Court can be vastly expanded.
Your Honor, in my humble view, I do think from a factual standpoint, this case is somewhat unique. I acknowledge, often, if you look at my argument, it's not based on anything that the defense presented. No, I take that back. That's the substantive argument. And I understand that Your Honors don't have the benefit of that. But the attack was on the fact that the Commonwealth's evidence was the testimony of the alleged victims, the only people that can put my client at the scene, testifying at trial that they do not know who the shooter was. And then the Commonwealth...
Go ahead and finish your answer. I'm sorry.
Introduced inconsistent statements. They have no forensics. They have no video. They have no admissions from my client. That's all they have. And I would venture to say that that's, from a factual standpoint, rather unique.
Okay, Mr. Ging, Justice Baer, and either my colleagues are lost or I'm lost. It's altogether possible that I'm lost. But let me see if I can straighten this out. First of all, I thought this was a hung jury rather than a mistrial. Is that right or wrong? Procedurally, I thought the jury hung on the charges involving the homicide of Ms. Minert and Minnie's death, and 2 counts of aggravated assault and 2 counts of REAP.
That's correct, Your Honor. Once
Okay.
I apologize. The jury came back and indicated that they were hopelessly deadlocked on a number of charges, that the trial court sua sponte declared a mistrial. Defense counsel objected, and he claimed...
Well, hold on for a second. Then I thought that Judge Bickett gave you a new trial.
He did, Your Honor.
All right, so we have a hung jury and we have a new trial. Then I thought that this appeal was about whether procedurally you can proceed to the Commonwealth Court, and had nothing whatsoever to do with the merits of your case. I think what my colleagues are saying to you is when you get to the merits, you're going to lose miserably. I don't know that. I haven't read briefs and I haven't studied it. But I thought that the only issue before us is whether you get an opportunity to argue those merits. Is that really right?
I agree, Justice. Yes, my brief for this report doesn't include any sort of merits analysis of the underlying issues.
And so Rule 311A6 says,
right,
in a criminal proceeding awarding a new trial, defendant claims that the proper disposition of the matter would be an absolute discharge, that there's an absolute right to trial. And that's where you are.
Yes, Your Honor. If you look at the note to that rule, it doesn't expound upon that. So then I looked to the case law, and I came across the Chennett and Liddick cases, which are Supreme Court cases. And Chennett says, quote, an interlocutory order denying a motion and arrest of judgment based on a claim of insufficient evidence when a new trial has been granted is immediately appealable.
You're here because you want to argue the merits, even if you lose them miserably. Is that right?
Yes, Your Honor.
All right. I think I do understand it. I'll have to see what my colleagues have to write.
The court didn't declare the court only declared a mistrial because the jury was it didn't. You see what I'm saying? So you're in a mistrial situation now. And the remedy is, all things being equal, the court can go ahead and reset the case for trial, right?
In a normal situation, I certainly would agree with that.
Okay, and then, yeah, but the motion for arrest of judgment, the motion for this, the motion for that, the trial's over because the jury hung. And then, your argument is, at base, unless I miss it, that your client shouldn't be retried because the evidence was insufficient. You see what I mean? And as you said in the argument today, that's intertwined with double jeopardy, because if the Commonwealth hasn't adduced sufficient evidence to support a conviction, you shouldn't again be put to a trial.
Yes, Your Honor.
Counsel, if I may, again, let me fall back on Richardson. As I read and understand Richardson, a deadlocked jury does not implicate double jeopardy. Therefore, explain to me how your motion implicates, quote unquote, the proper disposition would be an absolute discharge pursuant to Rule 311. It's not, to tell me where this absolute discharge is coming in face of the lack of jeopardy attaching.
Again, our position is the case should have never gone to a jury for disposition.
But it did. Because unfortunately it did, and this is the procedural posture we're in. So it's a very simple question. The jury came back hung. We have case law, that's United States case law, says jeopardy does not attach. Rule 311, which is our rule, says that there has to be an absolute discharge. Where are you finding your absolute discharge based upon United States Supreme Court precedent?
Our position is the absolute discharge should have occurred when the motion for judgment of acquittal was made at the close of the Commonwealth's case. If the evidence was insufficient, the case should have never gone to the jury. Jeopardy obviously attached when the jury was sworn in, and there shouldn't be a retrial.
Well, I apologize. That's just an abuse of discretion then, which is not before this court. That's not the issue. Yeah, you have a perfect argument, but that's not before this court. That is a different Ellicott type issue. You didn't raise it. I'm only asking you with regard to the case before us right now. Go ahead. I apologize, Justice Webb.
Yeah, I just wanted to follow up on Justice Doherty's question. And again, the Chief's line of questioning. You didn't go the 587 route. It's not something you've briefed. It's not this case. Instead, it seems you want an idiosyncratic exception to what the rule says, what 311 says, because your client's really, really special, or you really feel strongly about the insufficiency of the case. I said hundreds of cases. That's thousands of cases. And you did not get an award of a new trial. The jury hung. The judge declared a mistrial. You sought a judgment of acquittal and an arrest of judgment, which was denied. So absent the finding under Rule 587, you got to go to trial again. And if it's insufficient, it's insufficient. I just don't understand the limiting principle that you can articulate for us today beyond saying your client's special or this was a really bad mistrial. That would give us a defining principle to lay out a rule that would guide not just the court in your case, but courts around the Commonwealth. And I'm not seeing what that is.
Just to be clear, Judge, we did pursue the 587 mechanism. Again, it's through a different appeal, but we did appeal the declaration of a mistrial. We did argue that it wasn't based on manifest necessity. The trial court denied that, found that the issue was frivolous. We petitioned the Superior Court for review. They denied it in a per curiam order. I filed an aliquotter to this honorable court, and that was denied. So
Mr. Gang, it's Justice Todd.
Yes.
I thought I understood the case going into it, and now I'm not sure I do. It seems to me, first of all, that your argument regarding manifest necessity is completely irrelevant because this was a hung jury, right? That's different than a prosecutor saying something that was objectionable and the jury is prejudiced allegedly, and you argue there should be a mistrial because of the manifest necessity. That's not this case, is it? This is a hung jury case, results in a mistrial.
You're correct insofar, Your Honor, that it's not pertinent to what's before this honorable court, but it is this case. When the jury came back and indicated, and I hope I'm addressing your question, came back and said they were hopelessly deadlocked, defense counsel objected to the declaration of a mistrial. His sense was, Your Honor, they haven't been out that long. I mean, this is a complicated case. We don't want a mistrial. in the trial court said, well, I'm declaring one anyway. The trial court never elicited, like, Commonwealth, what do you think? Should there be a mistrial? He just sua sponte declared one. And we
So
did
your argument is kind of that the hung jury wasn't really hung, that they could have gone back and deliberated and reached.
Yes, Your Honor.
Okay, thank you.
Okay, thanks, Mr. Bing. We're going to hear from Mr. Strale.
Thank you.
Mr. Strale, you can open, but I'd ask you, essentially the same question. Doesn't your agreement to an appeal as of right here, without any screening for frivolousness, undermine the objective of Criminal Rule 587 to curtail frivolous interlocutory appeals?
Chief Justice, there's another aspect to that question. It's the fact that the jury did bring back a verdict. They found this defendant not guilty of 2 counts of criminal attempt homicide. And as this played out in the lower court, it was more a question of res judicata, collateral estoppel, and Ash v. Swenson, coupled with the double jeopardy issue about whether the mistrial was declared too soon. So as I looked at this case, I saw it as more as an Ash v. Swenson issue, where this defendant is saying that the fact that the jury acquitted me of 2 very serious charges in this murder case constitutes a finding that I was not the shooter. And that's exactly.
I didn't see that in any Alicata petition.
That was the issue in Superior Court, Your Honor. And as Superior, and this is my problem with Superior Court, and Justice Wecht, I don't like the analogy of taking a knee. That was your description. This is why I believe Superior Court erred. Superior Court, they relied on 3 cases to find this was not a proper 311 appeal. They relied on, first of all, Commonwealth versus McPherson. In that case, there's a hung jury, went back for retrial. There was a delay. The defendant moved to dismiss under Rule then 1100 for a speedy trial violation. That was not a proper appeal. The 2 civil cases that Superior Court relied on, Justice Mundy, you sat on one of them. Justice Todd, you sat on the other one. Johnson v. Frazier, Justice Todd, was the case that you had sat on. And that was a situation where a judge in a civil case granted an oral motion for new trial, despite the fact that that does not exist under the rules of procedure.
Commonwealth, this is Justice Doherty. Permit me, are you agreeing with counsel that there's insufficient evidence to bring the defendant to trial?
Oh, no. No, in fact, I argued that in Superior Court. I think that this is a frivolous, meritless appeal. But it's a situation where this court, and to answer your other question about Richardson, we have a Pennsylvania Constitution, and we protect double jeopardy, and we for privacy, we give more protection. And in this case, what I found was we have a guy, a defendant charged with murder, jury brought in a verdict finding him not guilty of certain charges, hung on other, and he has a new trial. And he's saying that res judicata collateral estoppel prevents this trial from going forward. I think that that is a proper appeal under 311A6. A new trial was granted. And I don't think we cannot, the nomenclature, was it a new trial? Was it a retrial? If you're going to come at me with that argument, the only thing I'm going to say to the court is, what do you do under Rule 600? When does this defendant, when does he have to be brought to trial? Because Rule 600 uses the word new trial. It doesn't talk about
Counsel, permit me. You indicated that we should follow our own precedent. The 2 cases that that's noted is Liddick and Jeanette. Both those cases involved the procedural posture of a conviction, not a hung jury. Share with me the case in which this court has ruled that double jeopardy applies after a hung jury resulting in a mistrial.
Well,
I'm asking you because you've implicated that this court is ignoring our own precedent. So I ask you, I can easily distinguish Liddick and Jeanette from these facts. basically just on the conviction. I'm asking you, give me a case that defies Richardson that this court has ever decided.
Oh, there are no cases that.
Exactly. Fair enough. Fair enough. So your comment was disingenuous, counselor.
No,
Yeah.
Justice,
But we could go on.
I'm not disingenuous because I'm talking about the philosophy of the court. This court has held for centuries that it protects the rights of defendants. And in a collateral estoppel res judicata situation, I think the Pennsylvania Supreme Court, the case law, the policy discussions about protecting defendants' rights are clear. I was not being disingenuous. I was not. If the
Let me
court,
follow
if you
up.
think I was, I apologize.
Mr. Striley, can I follow up on Justice Dougherty's question? In responding to him, you talked about philosophy and policy, and that's in line with your brief in which you call the Superior Court short-sighted and condemn their, quote, strained descent into nomenclature. I think you meant dissent. You don't like nomenclature, I guess by which you mean we should just ignore the text of Rule 311A6. I have no idea why you're making this argument, and I'd be shocked to hear that your office has ever made this argument. But in any case, you obviously agree with Mr. Ging that Mr. Wardlaw is really, really special. What I'd like you to comment on, and by the way, in your brief, you seem to suggest that you want our appellate courts to start parsing and examining what differentiated the mistrial. So to take these cases on an interlocutory basis, even when 587 is not in play, to take these cases on an interlocutory basis, and then I guess you would require our Superior Court to enmesh itself in comparing and weighing on this interlocutory basis the relative merits of the mistrials and the nature of why the jury hung, and basically every sufficiency challenge is going up on an interlocutory basis. So I'll ask you, as I asked Mr. Ging, what is the limiting principle?
The limiting principle, Justice Weck, is where a jury brings back a verdict and acquits a defendant of certain serious charges, that if you buy the theory that the acquittal constitutes a ruling on a factual issue, that the defendant cannot be retried. That's the foundation. This jury came back acquitting him of 2 charges of criminal homicide. His argument is those acquittals demonstrate that the jury found that he was not the shooter. The issue of identification controls. And
acquittals of attempt.
Pardon?
Sorry, acquittals of the attempt.
Right.
Not on the homicide.
Criminal attempt.
Yeah.
Right. And, Your Honor, 2 acquittals, res judicata, collateral estoppel, Ashby Swenson. I think that those issues are serious enough to allow a criminal defendant to take the appeal. And I think that those are the distinguishing issues in any other case that just has a simple hung jury.
Okay, thank you, Mr. Strally. We apprehend the arguments, but I think occasionally, as I've said before, I think when you make these concessions, you might want to think about advising the Attorney General and inviting his participation as amicus, since he is the chief law enforcement officer of the Commonwealth, and since these cases do affect every judicial district in Pennsylvania, but that is just my thought. So with that, we'll conclude the argument and take a 5-minute recess. Ready, Brian? What's your son? Speak to his counsel in this case. Counsel, which party?
Sorry. This matter is Terra Firma Builders versus William King. Representing Mr. King is Andrew P. Stafford. Representing Terra Firma Builders is Mr. Dave McCara.
Good morning. I understand counsel of the Aplt will be available by phone, so hopefully McCara can hear us. But anyhow, we'll start with the appellant. This case involves the timeliness of a petition to strike a lien under the Mechanics Lien Law of 1963 for failure to perfect a lien. The issue is whether a property owner who seeks to challenge the perfection of a mechanics lien may do so at any stage during the litigation, including after trial. Mr. Stafford.
Thank you, Mr. Chief Justice, and may it please the court. My name is Andrew Stafford, and I represent the appellants, William and Melanie King. Your Honors, the mechanics lien law is crystal clear. And 502 states that to perfect the lien, an affidavit of service must be filed. If no affidavit is filed, then the lien must be stricken. This court for over 100 years has held that the affidavit requirement is mandatory, that the perfection of a lien is conditioned on the filing of the affidavit, and that where no affidavit is filed, and the courts have no discretion and must strike the lien as a matter of law. There's no dispute here that Terra Firma failed to file the affidavit, but the Superior Court nevertheless ruled in favor of Terra Firma. And in doing so, the Superior Court became the first appellate court in this Commonwealth to excuse a contractor from failing to file the affidavit. Now, according to the Superior Court, Section 505 of the law imposes time limits in which a property owner must object to an unperfected lien. Yet, based on the very language the Superior Court relies on, it unambiguously imposes absolutely no time limit. And in fact, the Superior Court's decision not only contradicts the long-standing precedent issued by this court, but it contradicts the clear mandatory language of Section 502. Thus, I respectfully request this court to overturn the Superior Court's decision and to strike the mechanics lien. And unless the court has any questions right now, I'll proceed to my argument.
Counsel, this is Justice Donahue. Once an enforcement action is filed, an action to enforce the mechanics lien, does the mechanics lien claim merge with that enforcement action?
It doesn't, and typically.
Why is that, counsel? Because I'm looking at Section 1701, which is the procedure to obtain a judgment, and certainly within those sections, subsections of 1701, there are very definitive timing requirements placed upon, when an action can be commenced, when a judgment can be entered, how long it takes, goes through an incredibly detailed procedure about the tolling of the time in order to get to the 5 years. And so, I mean, as I look at this, I think there's an argument to be made that once that enforcement action is filed, the mechanics lien claim merges with it. So tell me why I'm wrong about that.
Well, it doesn't merge because the mechanics lien claim and the action to obtain a judgment on the lien are completely distinct actions, and typically they're filed as distinct actions. They have their own docket numbers. This court has held that the lien can be stricken at any time after it's filed. And it's clear that
Have we ever discussed the interplay of the enforcement action with the mechanics lien itself? I mean, that is essentially what the Superior Court did here, raising an issue that I understand is the first impression, which is once the enforcement action is filed, then any objections to the lien itself must be raised within the context of the enforcement action by way of a preliminary objection or, by way of new matter. Have we ever ruled on that issue?
No, and it was a case of a first impression before the Superior Court as well.
Correct.
But it's clear that if a lien is unperfected because no affidavit is filed, then the objection would have to be filed to the lien itself. And this can happen at any time.
Can I just probe that? Because, honestly, I have always found mechanics lien law to be very complicated. And so I'm just trying to figure this out. Certainly, once the enforcement action is filed, a preliminary objection could be, a demur could be raised saying, this action needs to be dismissed and the claim discharged because there was no service. Alternatively, new matter could be raised saying this claim has to be dismissed and the claim itself discharged because no service was made. What's wrong with that protocol for dealing with the mechanics lien once the machinery of the judiciary in terms of a common pleas court action to enforce has been raised?
Well, the machinery and in any objection concerning the perfection of the lien, again, it would have to go to the lien itself. And that's what the clear language of the mechanics lien law says. In Section 505, it says that if any defense or objection is to be made, it has to be made to the lien. And it's because the service requirements of the lien really have nothing to do with the action to obtain judgment on the lien. And the rules of civil procedure govern the actions to obtain judgment, and they're completely silent as to the filing and the perfection of the lien. And in fact, it's Rule 1651 that says that the procedure for filing the lien is controlled by the mechanics lien law and not the rules of civil procedure. And in fact, this court just 5 years ago stated that the procedure and practice for filing and perfecting the lien is governed by the mechanics lien law. So therefore,
But that's different. That's different than a challenge to, because the mechanics lien law itself says that if you don't file your objection preliminary, I would say, to an enforcement action, you're not precluded from raising that defect as a defense. To me, when it says raise it as a defense, it means raise it in a defense in the enforcement action.
but that's the problem. That's the problem, and that's the error the Superior Court made. The defense has to go to the lien itself and not to the action to obtain judgment. And again, Section 505 of the lien law makes that clear. And the rules of civil procedure, which governs actions to obtain judgments, are completely silent, and they, in fact, direct those back to the lien law. And that's what this court has held in the Terra Technical Services case just 5 years ago.
Can I follow up?
Justice Todd, excuse me. Justice Baer, may I go?
Sure.
Mr. Stafford, you acknowledge that this is a case of first impression for us to try to figure out the interplay between the objections to mechanics lien process and the enforcement in a civil action. If we're trying to set this right and make it practical and make it simple, why not just allow both? Why not allow the merger into a civil action for enforcement. It seems to me that in the interest of efficiency and judicial economy, that makes a lot of sense.
Well, this court can merge the two actions, but since 1901, any objection to the perfection of the lien logically would have to go to the lien itself, because if an affidavit is not filed, that means the lien is void and it has to be stricken as a matter of law. And courts have made clear that once the lien is stricken because it's void, then the action to obtain judgment on it falls. So it may be impractical that years after the lien is filed and an action to obtain judgment is commenced, that the objection would go to the lien, but that's what the clear procedure requires.
So, Mr. Stanford, may I follow up on both Justice Todd and Justice Donoghue? And I think we're, good job by you, we're in the heart of this case. You read 1502 as if it was the only section of the mechanic lien. If I understand your argument, it's that 1505 and 1701 have nothing to do with 1502. Now, is that fair to you or not?
That is fair. And 1502, which requires the striking of the lien, existed way back in 1901. And in fact, Section 21 of the Act of 1901 is identical to Section 502 of the current law. And both those sections make clear that the affidavit is not filed and the lien is void ab initio and it has to be stricken. 505 of the current law changes nothing. 505 was created to make it easier for property owners to remove void liens at a preliminary stage of the litigation. And if you look at the comment of Section 505, the purpose of 505 is revealed. 505 states that under the old practice, if a property owner wanted to challenge the perfection of a lien and a factual dispute arose, then the matter would have to be taken to a jury. And as you might imagine, that was an incredibly inefficient process. The General Assembly, in creating the current law, said, well, let's allow parties to do what they do under the Rules of Civil Procedure. Let's allow property owners to file preliminary objections at a preliminary stage of the litigation, and that matter will go right to the judge and not a jury, and the judge will decide the preliminary objections. But the General Assembly made pains to emphasize that preliminary objections under Section 505 are very disliked preliminary objections under the Rules of Civil Procedure, given that there is no waiver, meaning you can file the preliminary objection to a void lien as a defense in any subsequent proceeding.
So let me ask you, I mean, we all know that you can raise subject matter jurisdiction in a typical case as a lack of it is a complete bar. So you can be arguing in the United States Supreme Court 20 years after the case began, and you can say, Your Honor's no subject matter jurisdiction, and they have to dismiss the case. And you take a more extreme position. You would say the United States Supreme Court can finish with this case. It can be finally concluded through multiple layers, and you could come back 15 or 20 years later and say, aha, but they never made service. Strike it. Is that fair?
It is fair. And in fact, there's at least two cases that have allowed that. There are two Superior Court cases where judgment has been entered on the lien, and courts have allowed property owners to strike the judgment because no affidavit was filed, which makes the lien void, and therefore the judgment entered on the lien is void as well. Now, to take your hypothetical, I can't imagine someone would wait 20 years to strike a lien, but under the plain language of the law and under Section 502 and according to 100 years of precedent, property owners are permitted to move to strike unperfected void liens at any time.
But counsel, can we just follow up on the pragmatic effect of what you're saying? Take this case, for example. Your client waited 5 years to raise this defense. I mean, and I can only think it's because they missed it. Because there was a previous action filed and there was service on that, and then somewhere along the way it got missed that was dismissed and a new one was filed. During the course of those 5 years, Court of Appeals spent judicial time and resources adjudicating the enforcement action and the other attendant claims. I mean, given that, in Section 1701, there are specific time limits on when the enforcement action has to be brought and things of that nature, why would we not assume that given these procedures that the intent was once that happens, you're dealing with one action? And certainly, if the defect in the lien is raised during, at the new matter or preliminary objection stage, you're going to win. You're going to win because there wasn't perfection of service, and a demur is going to be granted or whatever it would be on a new matter claim. But 1701 means nothing then in terms of. Let me ask you this question. Maybe I just misunderstand this. Time commencing action. This is 1701A, 1701B. It says an action to obtain judgment upon a claim filed shall be commenced within 2 years from the date of filing unless the time be extended in writing by the owner. Doesn't that mean that an action to enforce that lien has to be filed in 2 years?
It has to be filed within 2 years after the lien is filed.
Okay, and what if that doesn't happen? Suppose 3 years go by and no action is commenced. Then what happens to that lien?
And that means the lien can be stricken because it's impossible for the contractor to obtain a judgment on it.
Okay. So, but once the contractor commences the enforcement action, doesn't that subsume the lien itself? Because you can't have an action without a lien.
Right. But the problem is that the lien itself would still be void if it's not perfected. So therefore, any action commenced to obtain a judgment on the lien could not stand because the lien itself would be void.
And that can be raised within the enforcement action. And the enforcement action would then be dismissed and the lien would also be discharged.
Correct. And the defense would be raised to the lien itself, not the enforcement action.
Well, no, within the enforcement action, I mean, you parse those words within your brief also, but within the enforcement action, it would be on preliminary objection, a demur. This action cannot proceed because the lien has not been perfected. That's what the demur would be.
Well, you necessarily wouldn't raise a demur because you would not be raising the objection to the action to obtain judgment. Again, you would be raising the defense or the objection to the lien itself.
Unless they merged.
Unless they merge, which typically I don't think occurs. But Your Honor, the simplest answer to this is that if the General Assembly wanted to impose time limits, they could have easily have done so. There are at least 5 other sections within the entire mechanics lien law that have explicit time limits, but there are none in Section 505. The last sentence says that the failure to raise an objection preliminarily is not a waiver of the right to raise the same as a defense in subsequent proceedings. That's at any time, and that's consistent with the long case law that has allowed property owners to even move to strike judgments.
Mr. Stafford, Justice Baer again. I'm sorry, Justice Donahue, I was following up on you, but if you're not done, go right ahead.
I just said thank you.
Okay. And I think Justice Donahue and I are tracking in the same means, which is perhaps inconsistent with you, which is why everybody giving you an opportunity. When I look at 1505, at the beginning, it doesn't say only your client can object, which is the way I think you interpreted it. It says any party may preliminarily object to, and I'm going to skip a few words, lack of conformity with this act. So it seems to me that puts the onus on your party to preliminary object for failure to serve, which is a lack of conformity with the Act. And it takes 1701, 1505, and 1502, and it says, notwithstanding what the law was in 1901, read them in pari materia, they're all part of the Mechanics Liens Act. Now, I appreciate what the last sentence says, but let's just start with that. Isn't that a fair reading of 1505, that your party has an obligation to object to lack of conformity with the Act, which in this case is a lack of service?
There is never an obligation on the part of the property owner to object timely. There's nothing in Section 505 that states that a property owner must file preliminary objections. And again, the comment is crucial. 505 was created solely to benefit property owners, to allow them to move to strike a lien at an early stage of litigation. There's nothing that obligates them to do so. And in fact, under the clear language of Section 502, which states that a failure to file a lien or an affidavit shall be grounds for striking the lien, you can file a motion or a petition to strike pursuant to the language in Section 502, which was the procedure going back to 1901, and nothing under the current mechanics lien law changes that.
And then the last, go ahead, Justice Donahue.
Let me just call your attention
I
to
got it.
the last sentence in Section 1505, Section 505. Failure to file an objection preliminarily shall not constitute a waiver of the right to raise the same as a defense in subsequent proceedings. So, doesn't it at least mean that the defense of the lack of perfection has to be raised in the subsequent proceedings?
Well, if it's not raised preliminarily, then yes, it would have to be raised in a subsequent proceeding.
And do you agree that the enforcement action is a proceeding subsequent to the filing of the mechanics lien claim?
It is, but again, the objection would not be raised to the enforcement action. It would be raised to the lien.
Okay, Mr. Shepard, any other questions?
No, we got it, Chief.
We'll hear from Mr. Terra.
Good morning. May it please the court. David McCara on behalf of the Aplt, Terra Firma Builders, LLC. This case, from our perspective, is certainly one of first impressions. The King's waiver of their right to challenge the mechanics lien based upon the service issue is a case of first impression because, unlike many of the cases which have been cited in the appellant's brief, the Kings here failed to file preliminary objections to the lien itself. They failed to file preliminary objections to the complaint to enforce the mechanics lien in the enforcement action. They proceeded to trial in an action consolidated with the mechanics lien, a civil action, and failed to raise any service defense to the lien at the trial. And they thereafter failed to raise any such issue in post-trial motions after the case was tried. Now, we concede there's an obligation to serve the lien and an obligation to thereafter file the affidavit evidencing service within 20 days. However, that obligation or the defense to that obligation raised by the homeowner can be waived if it is not raised. And this is a case of first impression because the trial was complete and finished without it ever becoming an issue raised by the homeowner until approximately 9 months later.
Counsel, could I interrupt? This is Justice Wecht. Since you can't see me, I'll tell you who's asking you the question. You concede that you blew it. Your clients blew it. They failed to file the affidavit. You talk about waiver. You talk about the homeowners' failure to file POs. 505 specifically says failure to file POs is not a waiver. So I have to presume, and based on your brief, I think I'm correct in presuming that you're arguing an equitable doctrine of latches. And could you explain for us how we are empowered to import this equitable latches type argument into a statutory regime? In other words, isn't your argument with the General Assembly, which prescribed this statutory procedure and allowed these people apparently unlimited time to move to strike off the lien for your failure to file the affidavit?
Well, thank you. And let me address Section 1505 of the Mechanics Lien Law first. I disagree respectfully that Section 1505 provides that the opportunity to challenge the mechanics lien set forth in 1505 cannot be waived. And specifically, the last sentence of that section, which provides failure to file an objection preliminarily shall not constitute a waiver of the right to raise the same as a defense in subsequent proceedings. As the Superior Court touched upon in its opinion, this speaks only to preliminary challenges to the mechanics lien itself. And I would argue that the phrase subsequent proceedings pertains specifically to the trial of the matter, which took place in this case without that defense ever being raised. So the failure to raise it at trial is the failure to challenge it in the subsequent proceeding as designated by Section 1505. With regard to the lashes issue, it's our position that the case of Simango versus Hobbs, which is referenced in our brief, acknowledges there are circumstances in which the failure to file the affidavit may be waived by the defendant homeowner, and that case specifically acknowledges and deals with the fact that the doctrine of lashes applies in the context of a waiver argument on a mechanics lien, notwithstanding its origin as a creature of statute.
In counsel, it's Justice Bear. Can you respond directly to Mr. Stafford's sort of adamant position that Section 1502, premised upon 100 years of law, stands alone, and notwithstanding what 1505 says or 1701 says, they don't have anything to do with this? Did the law change at some point over the 100 years? Or is it just a misconstruction?
I'm sorry. The mechanics lien law has been amended a number of times since that time. And there's been a body of case law which goes back and forth under the mechanics lien law as to whether substantial compliance is enough in certain circumstances and whether strict construction of the mechanics lien ought to apply, and which of those applies in the context of procedural as opposed to substantive interpretations of the statute. And I think it plays back into an issue that Justice Donoghue raised during the appellant's argument regarding the Terra Technical Services case, which I had the pleasure to argue before this court. And the Terra Technical Services case stands for the proposition, which is somewhat related to the issue here, which is that an enforcement action brought following a mechanics lien can be filed under either the same docket number as the mechanics lien was originally indexed at, or at a separate docket number. And either is acceptable in terms of procedure under the mechanics lien law. Having said that, where the two cases merge, as Justice Donoghue suggested, then any challenge to the lien would have to be filed but what it would then be both the enforcement action and the mechanics lien action. So those merged or consolidated actions would then be the sole basis for any challenge to the mechanics lien law. The mechanics lien, I mean. And it not being raised there, and that matter being tried in its entirety before a judge, is the case of first impression here, where that challenge is never made. The homeowner has to, at some point, have waived it. Otherwise, their right to challenge the mechanics lien goes on in perpetuity, hypothetically.
Which indeed is precisely their argument. I got it.
Okay, any other questions? Thank you very much, Mr. McCarroll. Thanks, Steph. That we're going to recess for 1 hour and reconvene at approximately 12:45 to hear argument in the remaining case. Thank you.